All right, so we're continuing on the journey. 1, do very little. 2, don't claim authority. 3, don't pay anything out of pocket, with that caveat being the funeral. 4, talk to an attorney. Determine, what attorney you want to work with and how you want to move forward with that. 5 is don't distribute. 6, probably the most difficult, don't let anyone spend, take, or use assets of the estate. Number 7 and number 8 are, or you could do one or the other in either order. They're going to be very, very integrated with each other. But the video about probate goes into more detail about this. This situation it's very, very important to understand what's in an estate and what triggers probate. It is uncountable the number of times that someone has said to me, well, he had a will and the will said X. Like, I should get this, or this is how it should be done, or here's who's in charge. The reality is a lot of people don't go through probate, so the will has very little effect. Indiana, as I mentioned in one of the earlier videos, probate is triggered if you have $50,000 in your name after you die. There's a whole lot of ways you can own property or put beneficiaries on property that would move property in the moment after you die before we count. So if you kind of picture, there's this legal magic moment after you die, and there's things called non-probate transfers that will move that property out of your name. You could have $1 million here. In this magic moment, it all moves, and then we go to count. There's actually nothing in your name, or very limited amounts of assets in your name. If after that process we get to a point where there's $50,000 or more, then we need to evaluate whether we should or probably need to go through probate. What are some of the things that would bounce it out? So I have $1 million. I have a $300,000 house that I own jointly with my wife. I own it jointly. I die, my interest dies. The house is in my wife's name. That's not countable. I have a $250,000 life insurance policy. It has beneficiaries. Those beneficiaries are going to receive the proceeds of that life insurance policy, and so it will go without needing to go through probate. That puts me at $550,000. Let's say I have $50,000 worth of vehicles held jointly. Those vehicles are going to go to the survivor, and my interest dies with me, so they're not countable. That leaves me $400,000, and I'm going to have $400,000 in my IRA, and that has beneficiaries, so it's going to go to the beneficiaries without going through probate. There's $1 million estate that now needs no probate because we did non-probate transfers. Some people have trusts, and the trust have the ownership of that asset, so it's not counted. There's a thing in Indiana called transfer on death and payable on death, which is kind of like putting a beneficiary on an asset that doesn't otherwise have beneficiary provisions. So there are a number of devices. This is the planning concept. Before we pass, we do a plan to avoid probate and put assets where we want them to be after we're gone. So that is non-probate transfers, and if done properly, we can avoid probate altogether. Now, let's say this has happened. I had this happen a couple of times this year where someone didn't have proper beneficiaries on their life insurance or annuity. And what happens at that point is the company says, there's no one named, we can't distribute it out to someone, we're going to pay it back into the estate. Now, both those situations, one was $200,000, the other was $95,000. That is greater than the threshold necessary for probate. We ended up going through probate for a single asset. Then unfortunately, we wouldn't have had to have done it all if the beneficiaries would have been right. So that said, we now have to go through the entire probate process to move that asset to eventually beneficiaries of the estate. That said is one of those things where, again, people think, had a will, I was in the will, I said I was in charge. If we don't have assets in probate, then we don't need to probate the assets. A will is your instructions to the court to say, here's who I want to be in charge, and here's how I want things distributed after everybody else is taken care of. If we're not in probate, we don't necessarily need the will. There's a few circumstances where we might leverage the will in small estates to make sure it's distributed properly, but it's not going through the court. We're just leveraging the will to represent what the person's wishes were. You can sometimes submit a will to the court. It's called spread the will of record, to put it out there so people knew the person died. I think the people who appreciate that most are genealogists, so we've got names and relationships in the public record. But it also does some other things to start a clock and end a clock and things of that nature. But if we don't have enough in assets to trigger probate, we may not have probate. I had a conversation with a young lady who called. Her father had passed away. He had a second marriage, and he had said for years he had taken care of her in a will. And the reality was, in the second marriage, everything was owned jointly, and all those assets went to his second wife. There was no probate. There was no requirement for her to share those assets with the daughter, and she didn't. And so basically the father, who may have thought he had done the right thing to take care of his daughter, accidentally disinherited her. So that goes to planning, but it's important to understand just because someone had a will doesn't mean the will is going to have any effectiveness over the distribution of assets. So it's really important for people to understand. And again, I'll go way back to the beginning. If everybody's on the same page from this foundational starting point, it'll eliminate some confusion down the road when people will say, well, I was supposed to get that, or I was supposed to be in charge, or these different things. A proper plan keeps us out of probate, and that's not a bad thing. The assets may go to people in a different way, but again, sometimes people don't understand the fact that if they put a child on a bank account, that bank account goes to one child. It doesn't go to all the children. And there's no legal requirement for that child to share it with anybody else. So sometimes that convenience thing of owning a bank account jointly becomes a detriment to the equal distribution of an estate to children. But that's not always explained to the person when they're doing that sort of planning. So it's really important to understand there's this process of moving assets out of a person's name if there is an action of law or a non-probate transfer on that device, that when we begin counting, if we don't get over that $50,000 threshold, then we may not need to get involved with the court. There's some other things called a small estate affidavit, and that leads right to 8. So 8 is once we determine what's in the person's name, that allows us to determine how we're going to proceed. So we've talked about probate. If you have property in another state, you may need to do an ancillary probate, a whole separate probate, usually a little slimmer, a little thinner, quicker, but to manage the asset in that estate. Well, we have a lot of clients that have property in Florida or Arizona or Michigan, Illinois. You've got to make sure that you know where those properties are and what the process is to go through the ancillary process. I've had to open estates in Indiana that didn't have any assets in it, but we had to open the probate in Indiana because that's where the person lived, in order to manage a property in Michigan or Florida or Texas is another client. So there's the time and cost associated with going through that probate process. And then you have to open another probate, and there's time and expense associated with that too. So probate, ancillary probates. Small estates, affidavits of heirship, devolution deeds, a fairly new vehicle in Indiana. But basically there may be something that was owned jointly that we need to now update the world as to how that's going to be transferred. So an affidavit of heirship, a spouse may file with the county to say, well, we owned this when we were married and living, and when this person passed, we were still married, and by the rights of, in Indiana, there's a thing called tenancy by the entirety. That survivor now has that property outright. It's updated in the record to reflect that. A devolution deed is used if we had a person that owned property and real estate, and we didn't need probate, but we have to go through a process of showing that the person owned it and who the rightful heirs are and how we get it transferred. So that's fairly new, still being worked through in some counties, but that's a devolution deed. A small estate affidavit or a small estate claim is something, let's say we had a $5,000 bank account, and that was the only asset in the person's name. I mean, it could be a $45,000 bank account. And what we're going to do is present a document to that financial institution or whoever holds that property to say it's personal property, not real property, to say that this person died, did not need probate. Here are the rightful heirs. This person represents them, or all four of them should be equally represented in the distribution of that asset to them. But we don't need court. And so that is a paper transaction. But some combination of those will allow us to move assets, and sometimes that's what happens when I do a plan. We may not have everything in a trust or transferred to somebody. We may have a few things out there, but they're less than $50,000, so we have to find the tool to move those things. Trusts is another thing, and sometimes people will do and have a need for trust administration. A trust administration is a legal process of working through closing out a person's affairs and then distributing the estate. It's very similar in structure and flow as a probate, except it's outside of court, and it should be quicker and nimbler if everything goes right. You don't have the same clock that you work under. There are still some responsibilities the trustee has to the beneficiaries named in the trust. And there's a lot of intricacy associated with those things, but it's another process that needs to be followed. It's possible that you need probate and trust administration because something was left out of trust. We had to go through probate. That's what this process of working through what we talked about in number 7, understand what's in the estate and what's not, and where it might be. We could find out somebody had, I always reference an F Coupe Jag convertible because it's a $100,000 car. That was only in his name. He passes. He had everything else in his trust. Well, now we have a trust administration and we have a probate for the vehicle. So that's what we would need to determine in that under the number 7, and then 7 dictates what we do in 8. Once we determine what it is that we're going to do, there is a schedule to follow. There are rules that we have to follow. There are things that we have to do. There's communication that's important. And one of the biggest things that we bump into where feelings start getting hurt, people start getting antsy, expectations aren't set right. Timelines aren't set right. Communication starts to falter. So the best thing you can do is, just keep people abreast of what's going on. Some people may set up a private Facebook thing or a website where you can communicate things that's not open to the public, but a way to communicate just kind of what's going through the process and when, and setting timelines and letting people know, hey, I'm going to mail you something. I need you to sign it and mail it back so we can move this thing forward. Going back to the don't distribute, you may not get the bulk of an estate or a trust distributed to the individual beneficiaries or heirs for several months because we've got to work through some of these other processes. I should add, when I said trust administration, just because you have a trust doesn't mean that Medicaid's not going to make a claim. You still have to tell Medicaid that the person's died, and if they have a claim, they need to make it. So determine what the path is. Stay on schedule, understand what that schedule is, communicate with everybody, just try to stay above board. Now that is also very simple to say because people will get over their skis and start to get antsy and, can't understand why they're not getting their money. But it's just, there's a process you have to follow. And again, as long as the person in charge is doing what he or she is supposed to do when he or she is supposed to do it, people complaining can complain. It makes it kind of a headache, but that doesn't change the process. And so it's important to do what you're supposed to do when you're supposed to do it, and then work to get things concluded. And that is bullet point 10. There's a lot of energy, if you will, and a lot of get after it and get it done at the beginning. But as I said, sometimes these probates can drag out for 9 months, a year, or beyond. I've got a couple that are a couple years old because of real estate or because of a challenge. It's real easy to lose focus and not finish. I've got a couple of probates where I've just lost track of the PRs. We're ready to close. We've been ready to close for months, but the PRs have kind of wandered off. So, stay on track, get it done, button it up. We'll know what the schedule is. We'll know what the benchmarks and milestones are. And it's really important that we finish strong. We don't need this to linger. We don't need to drag it out. Let's get it done in the fashion and the time that it needs to be done. So there's your 10 points. I hope you found this valuable and a good resource to help you kind of prioritize things and understand when you have to do things and when you don't have to do things. If there's anything that I can do to help address your specific circumstances, I sure hope you'll call and we can chat on the phone. We can set up a family meeting or a small group meeting, however you want to do it, and really work through your specific circumstances and understand how we need to get started and kind of the time frame of what it would take to get that rolling. I do appreciate the fact that this is an emotional period of time. I was very heavy on that at the beginning, and then I got super logistical. But understand, I believe and know that emotions are going to play a very important role in this. That's why I said in the finish strong part, you're going to have some people that are getting very, very antsy and start taking it personal because they're expecting money. Maybe they need it more than someone else. Maybe they feel like they're getting shortchanged. So we want to do as much as we can to understand that there are emotions. Let's not foster and fuel extra emotions. Let's work through the process and know that it is in fact a process with things to do at particular times and things that we don't have to do, right? So would love to talk to you about your circumstances just to help you, set a good foundation on how to move forward. I don't charge for that meeting. Really, we'll talk about, and we may not even charge for a second meeting if we have to still figure out what we need to do. But in the end, what we want to have is a good understanding of what the process is, what needs to happen when, what doesn't need to happen, and make sure that everybody has, the same story and that we stay focused and work through it. So you can call the number on the page, set up a time to meet. You can drop me an email if you have any questions that you would want to float in that way. I would look forward to the opportunity to serve you in this capacity, and I wish you well through this process.